Welcome to the Publishing Performance Show, the podcast that helps self-published authors turn their passion into a profit. Now, I'm your host, Teddy Smith, and if you're serious about building a sustainable business, then you're in the right place. Every week, I sit down with successful authors, industry experts, and publishing professionals who share their exact strategies they use right now to how they've grown their business, grow their readership, increase their book sales, and essentially to make a bit more money. Now, whether you're just starting out or you're looking to scale your existing publishing business, you'll walk away from every episode with actionable insights you can implement immediately. Now, if you're new here, it would really help me out if you could subscribe either on Apple or Spotify or YouTube or wherever you are. Just simply hit the subscribe button. It really helps the show to get more reach, which means we can get better guests for you and we can help you out in more ways. All right, let's dive into this episode. Hi everyone, and welcome to the Publishing Performance Show. Today I'm really happy to be joined by Dan Miller, who's the founder of the Copy Detective. So thank you for joining us, Dan.
Thank you. Thanks for having me.
No problem. So the main question I get asked a lot is, if I use any AI to write my book, who actually owns the content?
Well, if you're talking about from a copyright perspective, and that's how I approach it, since we're the copyright detectives, it depends on how you generate the content, how the AI content is actually generated. So if you start by simply putting in prompts into an AI platform, the output of that, according to U.S. Copyright Office and the courts, that is not copyrightable. That means it's unclaimable. So no one can actually claim that content if AI generates it just using prompts. Now, if you start from the other extreme, where you write the content yourself and then you use AI to tweak it or to develop characters or whatever it is for the book that you're using, depending on the level of AI involvement, it could be totally copyrightable or it may not. So in the US, if you're filing a copyright application, the examiner will actually decide on a case-by-case basis. The phrase they use is a de minimis amount of AI involvement or AI output. And there's kind of a test for that. If the content that AI generates, if it were created by a human, if it would be copyrightable, then that's not de minimis. So you have to disclose that when you file an application for copyright registration. And then the Copyright Office will disallow that piece. Now, the rest of your book is copyrightable. So that's really no different in the U.S. than the way it's always been. So if I used a public domain image or something else in a book and I filed the copyright application, I'd have to disclose that as well. So so AI has become kind of the fifth element, if you will, on what has to be disclosed to the U.S. Copyright Office.
Right. Okay. What does copyrightable actually mean? Because I know a lot of authors think that a book is automatically copyrighted just by the fact they've written it. So what does that actually mean when you say something is copyrightable?
Okay. The way it reads in the U.S. is the moment that you capture the content in a tangible form. In other words, you write a Word doc or something else, you create it. It's copyrighted in the U.S. The problem is, though, that beginning in 2023, you now have to have a certificate of registration from the U.S. Copyright Office for that work before you can file a lawsuit. So that's a major change just in the last couple of years.
Right.
We have a thing called a small claims court now that you can actually do it simultaneously, but here in the U.S., the best practice is to file an application for copyright registration within 90 days after publishing it. And then you could get statutory damages. So in the case of AI, obviously it was with full intent when they scrape people's works and everything else and make a copy of it. It could be up to $150,000 per claim, if you will, for each copyright infringement for that. So, some serious teeth in that if you file within 90 days. So the author has to take the effort to register it and get that certificate back to actually exercise their rights, if you will.
Right. Okay. So although when you write something, it is actually already copyrighted, if you ever wanted to take someone or you wanted to protect that writing, you would actually need to register with the right authorities in America, at least.
Yes. To be able to exercise that right. So, you have the inherent right to make copies, for example. That means AI can't make copies of your work. If they do, it's copyright infringement. And that's what's happening with AI right now. And in the US, there are currently 40 court cases that are open with people suing AI platforms for copyright infringement. And one just came out a couple of days ago. I had to revise a PowerPoint presentation I was about to make in a couple of hours. Disney and Universal Studios sued Midjourney, and
Okay.
there are 199 instances of copyright infringement in the lawsuit against Midjourney. So that's the biggest one. It's the first time a studio has actually sued an AI platform for copyright infringement. So that's a historic first for that.
Right.
And of course, Disney and Midjourney have deep pockets, so they'll be in lawsuits for a long time.
Yeah. If you are writing the stuff yourself, what is the first step? What are the first steps you need to take like in order to protect yourself? Is it just a case of registering it, or is there a specific process you should be following?
Well, part of the problem in writing, and we've done a couple of books that have taken years, and there's so many iterations of what's going on. So the key, I think, right now is for a writer to keep track of how they've used AI. So I encourage people to come up with some kind of tracking log, if you will, and I do that when I'm seeking permission for clients. That's our main job, is to go after copyright permissions, and so yeah, I encourage people to keep records. AI, some of the AI platforms like to keep a library for you of every prompt that you've done, so you can go back and find it. But in my mind, as you're developing your manuscript, if you use AI, make a decision right then whether or not it's de minimis. If it's a small amount, like Grammarly, checking the grammar or developing characters for a novel or whatever, make a decision then that this is a small amount. You don't have to declare it. So that's how I would do it. Is I just keep a record, and keep those files forever, if you will, because it's not only the U.S. Copyright Office that requires disclosure now. Amazon KDP requires disclosure of AI generated content, and if you don't disclose it and they find out later, they can pull your book from the bookshelf. So you won't have a distribution mechanism. So it's serious, and a lot of traditional publishers now are following that same principle, if you will, of disclosing the AI generated content, but some of them are actually going to where you have to declare the AI assisted content as well. So keep records is what I would say as you're developing your stuff, because it's too easy to forget. A week later you forgot where you got it. And that's true if you're quoting other content as well, is to keep track of where you got it, because a lot of authors will come to me and they don't remember where they got the content. So that's the first thing I have to do is, where was this published, and was it registered? Is it under copyright protection or not?
Yeah, I've seen Amazon have, about a year ago, they introduced that thing where you have to select like whether you used AI, like what tools you used and to what extent you used it. Have you seen anyone on Amazon so far get in trouble for not declaring something in the correct way?
No, I haven't. I haven't been trying to follow that, but the fact that it's part of their agreement that you sign when you go, that you will do that. So it's on an honor system. The problem is, if you don't honor the honor system, it can have serious consequences for you.
Yeah, I do wonder if that's going to change on Amazon at some point, where they're going to clamp down on it, because at the moment they sort of seem to just ask the question and then just leave it hanging out there. They don't ever seem to do anything about it. Like, I could just lie and upload a book that was entirely written with AI and no one would notice. But I feel like that will change.
Well, the whole thing about AI detection, that's what's going to get better. Now, I've played around with that, and I was not impressed with my first attempt. So we put in something that my wife had written before ChatGPT even came on the scene. So we know it's 100% human written. And the result was that the response was there's a 52% that this was written either by AI or by a human being. So I can't figure out what the other 48% was. Where did that come from?
They basically just said it could be or it could not be.
Yeah. But it's getting better. So I think AI detection, once those platforms are a lot more reliable, then Amazon could use it. Now, Amazon could also disclose that something has AI generated content. They're not doing that when people declare it, but that's something that Amazon could do. The marketplace may be where it settles out, though, because a lot of the stuff that's generated by AI, is not particularly creative, compelling or anything else. But again, AI is getting better also. So it's a double-edged sword, if you will.
Yeah. Now, with your practice, obviously you do a lot of work around copyright. It's not just about AI. It's all sorts of different types of copyright. So what are the different things that you're working on that sort of help authors especially?
Well, first thing we do is try to make a determination whether or not there's a copyright issue. Whether if someone uses a direct quote, for example, is that work actually under copyright or not? And in the U.S., there's 5 different copyright laws that are in effect right now. So that's the first thing I have to do is figure out, is this item still under copyright? And if it is, and you quote it, then you need permission. Now, there's a concept that we have here. We call it fair use. You call it fair dealing, and that's a big issue. And I still get questions weekly. I did XYZ. That's got to be fair use. Wrong. There's no set number of words that you can use without having to get permission or anything else. So the AI platforms that have scraped everything that exists out there, they're going to be using fair use as a defense. And so that's part of what I'm watching, these 40 new court cases that are out there. Each time I do a presentation, I update that. So far, there's only been one decision made against an AI platform, and that was Reuters sued Ross. Ross actually was trying to come up with a competitive news service. So they scraped everything that Reuters had, and which doesn't make sense. Basically, they're trying to pirate everything that Reuters had already done and sell that service. So they lost. So Reuters actually bankrupted the AI platform before the decision was finally made. But the courts are going to decide in the U.S. what is fair use and what is not fair use. And the U.S. Copyright Office's position is that some of them will be determined fair use and some will not. Well, that's a 50-50 chance too. So it'll all have to ride it, and it'll take years for this to play out in the U.S.
Yeah. You talked about some of the things that authors need to look out for there, such as using quotes and making sure that they're using the right citations and things like that. So can we talk about some of the basics of copywriting,
Sure.
of copyright laws that people need to be aware of, especially if you're a new author?
Okay. Well, the first thing is making a decision on whether to do a direct quote. And so I try to talk authors out of using so many direct quotes. First of all, it becomes cumbersome to read a document, if you will, if you just have direct quote after direct quote. And the authors typically do that to try to elevate the work, if you will, to show more scholarship. That's fine in a scholarly work if you're a student or whatever, but it interferes with the readability to me when you have so many quotes that just mess up the flow of everything. So make a decision. Is the expense of getting permission to use a quote equal to or greater than the cost? So can you justify it? Because we charge per source to get permission.
So do you need permission for all the quotes you use?
If the source is under copyright protection. Now, if the quote is in the public domain, then you can use that freely. You need to give attribution, of course, but you still need to, you need to always do that.
So what do you mean by that? So do you mean a quote, say if someone says something on TV and you hear it, then I guess that's in the public domain. But if you take it straight from a book, no?
No. So it's a matter of when it was published. So in the United States, right now it's a moving target because of the way the laws had changed. But anything in the U.S. before 1929 is in the public domain.
Oh, now, so you're talking about as in the public domain laws, as the general public domain laws, not just something that's in the public domain.
Right, but just because it's public. Now, for example, when you air this podcast that's out there, is you will own the recording, at least in the U.S. This is the way it works. You own the recording for that, and you own the words that you're saying, and I actually own the words that I'm saying, unless I signed a release.
Yeah.
And with some podcasts, they are asking you to actually sign a work made for hire release, which I won't do. So the fact that you broadcast it does not give anyone the right to take your podcast and reproduce it unless you grant that. So that's the issue. So
I did a podcast a couple of months ago about reproducing public domain books, things like Charles Dickens and stuff like that.
Sure.
That's really old. Yeah. So that I didn't realize that we're talking about the same issue here.
Yes.
But let me give you an example, right? Say you're doing a book about the American presidents and you wanted to quote something from someone recent, like Bill Clinton or Barack Obama or something like that. Like when you're using a quote in that context, say they've taken it from their book or something, are you saying you'd need to get permission from the book to use it, or can you just cite it?
Well, so in the U.S., if it is a work that's produced by a government official, a federal, not a state, a federal government official like the president of the United States or a senator, if it's in their official role, that actually is in the public domain according to our laws.
So that's a bad example.
You can quote Bill Clinton all day long. Now, you couldn't. Again, it has to be a government official who has produced that as part of their official role. Yep. If Bill Clinton writes a book, however, now you can't go quote his book without permission for that.
Right.
Because it's a different role. So it's role specific, and that's an exception to the copyright law is government official. So government documents and all of those kind of things are in the public domain. Is one thing. And Creative Commons is, I don't know if you use Creative Commons much, but a lot of people do use that. That's a different thing because it's actually a licensing mechanism, if you will, where the author puts it into the Creative Commons system with a particular license. And you can use that as long as you adhere to whatever the license says. And some of it is not commercial. So you can't use it in a book, for example, if it says non-commercial, because producing a book and publishing and selling it is a commercial enterprise.
Yeah. What about in another example? Say you're writing a book about writing skills, and you wanted to include some quotes from recent books that you admired. In that scenario, you'd need to ask permission for every single quote you want to use, or are you able to put like links and like APA quote citations and things like that?
If you're doing a direct quote, technically you need permission. Now, the author has to decide how much risk they're willing to take. And that's part of what I advise them. Now, what I encourage people to do is paraphrase it. Don't do a direct quote. In other words, put it in your own words. And the best advice that I've had about doing that is read what you're wanting to use, go make a cup of tea, sit down and enjoy it, and then come back and write what you remember.
Okay.
So, that's a practical tip on what to do. So rather than doing the direct quote, because in the U.S., there's no amount of words that's fair use. And in the U.S., a judge is going to decide whether it's fair or not when you're sued for copyright infringement. So that's the only way you're going to know whether it was fair or not. Fair use is when a judge decides. And the odds are not great that, unless you're doing news reporting or you're writing a criticism or you're a student, fair use gets very, very sketchy. It's a risk. And the more you quote, the greater the risk. If you were to quote, let's say there's a 10-line poem and you put that whole poem in your book, well, you've done 100% of the other work. So now you have infringed that entire thing. If you use 2 lines of a song lyric in there, song lyrics are not very long either. You have captured a greater percentage of that. And song lyrics are another thing that I do copyright clearance on. Particularly in the U.S., baby boomers like myself, we like to write memoirs and we like to include the lyrics from the songs that were popular when we were in high school. So, so I get that question often. The problem is, the Beatles do not need the publicity from the 2 lines of songs that you have in your book. They'd rather get paid. And we've actually had that occur specifically 2 lines from a Beatles song cost an author $500, and
Right.
that was about 15 years ago. So I hate to
Right.
think what the cost would be now. Audiobooks. I'm working on one now. I just started one now. A lot of people in an audiobook, they want to include songs, recordings, and that's a different set of permissions that we have to go through to get that. And song recordings for audiobooks really gives me a headache because you have 2 different licenses you have to get. Lyrics, you have multiple owners of the rights. So the worst case I had was the Bohemian Rhapsody. An author wanted to use the lyrics from that. Well, Freddie and 4 other people wrote the lyrics. He died. He left it to 5 other people. Now we have 9 writers and 2 publishing houses. So 11 entities owned pieces of 100% of the rights for the lyrics. And you have to get permission from all of them. So I try to talk people out of using lyrics in their book. You can, in the U.S., you can use the title without any problem. A title is not copyrightable in the U.S. So you can put in there, I really enjoyed Bohemian Rhapsody. Well, anyone who's reading your book is going to know what that is and know what the lyrics were for that. So you don't have to quote the lyrics in your book. So that's part of what I try to do is I try to help the authors reduce their risk, and a lot of times by doing something differently than what they're doing. So I spend a lot of time talking people out of things.
So if you had your character in your book walking down the street singing the words to Bohemian Rhapsody, you probably wouldn't want to actually put any of the words in there. You'd want to just say he was singing it.
Correct. Exactly. No harm, no foul that way.
Yeah. Now, are there any other things that new writers should be aware of when they're writing their books? And, we focus a bit on fiction. Like, is there any nonfiction things that people should be thinking about as well?
Well, actually, in the U.S., fiction works actually have more copyright protection than nonfiction works because it's more creative. So if you think about a fiction work, I'm a technical writer, so if you will, so it's nonfiction that where my expertise is. So I'm quoting facts. In the U.S., a fact cannot be copyrighted. Now, the expression of that fact can be. So, for example, if I wanted to say, the sky is green, I could take that position. If I copy somebody saying the sky is green, then, that's where I would need permission for that, unless it was something written from the 1800s. Now, the other thing I run into, though, is I get a lot of authors who use things, for example, that are published in the UK, published in Australia. So then I have to figure out what your copyright laws are. So we have the agreement between countries called the Berne Convention that says in the U.S. we'll accept what your copyright laws are and you accept what the U.S. copyright laws are. And you have, I think you have the life of the author plus 50 years is the current law that you have in the UK. And we have the life of the author plus 70 years. So I have to figure out when I get permission from the UK, is it under copyright in the UK? And how does that, if it is, and it wouldn't be. So sometimes it's under copyright in the UK and not under copyright in the US. So I have to sort all that out as well. So keep track of everything that you use, because if you don't know where you got it, how am I going to get permission for you? I have to find it myself. Yeah. So I have to do a lot of, that's why we call ourselves the copyright detectives, because we have to figure out where this stuff comes from. And then we have to figure out who owns the rights or manages the rights for that, and then get permission to use that. Give yourself a lot of time to do that. It could take months for me to go through and get a response back from the publisher for that. So don't wait until you've got your book and being laid out for printing before you start the copyright process. Start early. And it's even good to talk to someone before you get too far downstream to figure out what these issues are and what you need to keep track of. I had one author came to me. He had over 200 items that he didn't know where he got the content. It was a memoir about his college football days. Basically, it's he wanted to do a scrapbook. It was Glory Days. That was the name of the book, about his glory football days. He came back 2 years later, and he'd identified all the 200 sources. So I ended up clearing over 600 items for him in one book. It's an 800 and some page book about his glory football days for that. It was a legacy kind of a thing that he was wanting to do.
Yeah.
So keep track of this as you're going through the writing process, where you got every quote. Don't overwork the quotes, but it's too easy to forget where you got it.
For authors who are like just starting out and maybe on quite a tight budget, are plagiarism checkers a good place to start with looking for these copyright works, or are they not really strong enough?
You can use it. I haven't used them myself, but again, it's going to be an AI driven kind of a thing. So it's how reliable is AI? And right now, AI is not terribly reliable in a lot of instances for that.
Right.
There's a term, I don't know if you heard this, AI hallucinations.
Yes.
You heard that term?
Yeah.
So there was a study I found recently that about 30% of the outputs of AI are hallucinations of existing platforms. And with new AI platforms, it was as high as 79% hallucination. That means it sounds a reasonable response, but it's wrong. And a good example I saw on LinkedIn, and I've done it myself a couple of times, asking AI to identify the U.S. capital city with the shortest name. And the response was Montpelier, Vermont. Well, I think Dover, Delaware is a much shorter name than Montpelier, for example. So it's clearly, you could accept that as being correct, but it was totally wrong. So that's the problem with AI, is you could be getting things that you think are correct and are wrong. So I start with an AI prompt, and then I go to the original sources. Yeah. And that's what I check on. I'm looking for that in the original source. An example that I was looking up the hourly rate of CPAs in the United States. So I get this response back, and it's saying that on average it's X dollars an hour. I look at the sources, and I'll kind of paraphrase what I found, because I don't remember the exact details. But imagine it's Bubba's Bait Shop in Biloxi, Mississippi, a chat group, and they're talking about how much they paid their CPA. Well, AI cited that as a source, and I don't have a lot of confidence in a chat group talking about the hourly rate of a CPA. So I'm not going to use that as a source in a book that I'm writing. It doesn't have the authority, if you will, to do that. So you have to look at everything. So a phrase, I was using the phrase trust but verify. And that came from Ronald Reagan when they were looking at nuclear weapons and all that. Well, now I'm thinking don't trust and always verify if you're using AI. So I think that's the operative is, you can use it to start, and I use it for research all the time, but then I go to the original source that the AI platform is citing. So that's what I would encourage everyone to do. Don't just take the AI output, use that to help you find original sources for the content you're looking for.
Yeah, definitely. Now, we've talked quite a lot about the content of the book inside. Mm-hmm. Is there anything that people need to be aware of about the book cover and image use as well?
Yeah, you see AI all over. You go into a bookstore and you see AI everywhere.
Yeah.
Again, the way an image is created in AI is you put in a prompt.
Yeah.
And then it spits an output out.
And image is copyrighted in the same way?
No, that AI image is not claimable in the U.S. You cannot claim copyright because you didn't create it. The AI platform created it. The machine created it, if you will. And in the U.S., a machine cannot hold a copyright, nor can an animal. There's one where a photographer, Slater, set up a camera in Indonesia, and a monkey took all kinds of selfies, and then he published a book with all of these images, and he tried to get a copyright on it. And the U.S. Copyright Office says a monkey cannot hold a copyright. And it went through the court system and everything else. So PETA, a group protection of animal rights, sued this guy to try to claim the copyright of the selfies that the monkey took so that the monkey would hold the copyright. And that didn't go through. So the court said, no, monkey can't hold a copyright. I can't figure out how they'd cash a check anyway if they got royalties. So
just loads of bananas.
Yeah, a lot of bananas. That's how they paid bananas. So there's a lot of nuances. U.S. copyright, well, any copyright law is really complex, and I describe it as an onion. It has many layers, and every layer will make you cry. and you add AI to it, it's just a bigger, juicier onion that makes you cry even more. So you have to be very careful how you use AI if you want to claim copyright for it. If you're using it for marketing materials, you're not going to copyright that, more likely. So, so it doesn't make any difference. If you're wanting to protect the work, though, so that someone else does not copy your stuff, then you have to be careful with what you do and what you can disclose. It's complicated, though. If you get a copyright, you don't know what's actually copyrighted in the book and what's not. If I put public domain content in a book that I write, I can copyright the book, but those public domain pieces are not copyrighted in there as well. So you always have that problem with a book that includes other people's stuff. Is figuring out what is copyrighted. So what happens in the US, you mentioned this earlier, a book that goes into the public domain, I can go out and reproduce that. Now, if I write a new preface to it or I add illustrations or something else, I can actually file a copyright in the US for those new pieces that I put in there. Mm-hmm. Now, publishers do this all the time. They just slap copyright on the copyright page, but you don't know what's actually protected and what's public domain. So that's part of the problem we've always had, is to sort that out. What's actually covered and what is not.
Yeah, so, that's really interesting.
Yeah.
Now, quite a lot of the stuff we've talked about today, I think people might be a bit now worried about writing because there's so many pitfalls that they could come into. So let's finish with some good advice that people can do so they can carry on writing with confidence.
Good advice. Well, keep track of what you're doing.
Yeah.
So if you're wanting to use if you copy a work or if you write down a direct quote or something else, keep notes right there that this is, put it in quotation marks, put down the source of wherever you've gotten it for that. That way you'll have a record, or, scan it or, do a screen capture. I do a lot of screen captures with that. So keep good notes on what you've actually done. If you're wanting to use an illustration out of someone else's book, for example, make a copy of that table or that graph or that illustration, and also copy the copyright page out of the book where you have it. Because that's the first thing I have to do, is I have to try to find a picture of the copyright page, and I'll ask the author, go find the book for me. And because I need to know, when it was copyrighted, who copyrighted it, anything else for that. So keep excellent records as you go through. It'll save you lots of more time downstream as you're going through that. So a filing system is essential, and a filing, tracking your additions and revisions and edits and all of that is essential.
That's really good advice. Thank you very much for that.
Yeah.
Now, how do people work with you? What sort of the services that you offer that people should be getting in contact with you for?
So the first thing we do is we will assess a manuscript, for example, or they'll send me a list of all of the sources that they used to try to find out what is copyrighted and what is not. So that's the first thing that I do. So I'll come back. Let's say you give me a work and you have 100 different sources of direct quotes or illustrations or photographs for that. So I'll look at those 100 items, and then I'll do a quick analysis whether or not they could be under copyright. So in the U.S., it depends on whether it had a copyright symbol, whether it was renewed. I mean, that's what I'm saying. There's 5 different laws I have to go through to figure that out. And then, so let's say I come back and I say there's 89 of your 100 books that may be under copyright. So, do you want me to do the research to find out whether they are or not? So that's my time when I have to do the research. So, I can give you a quote to do the research. Or the other thing, I'll come back, I'll ask you to send me your manuscript with those quotes highlighted. And if I come back and I look at your manuscript and I see you used 5 words here, 6 words there, whatever, I'll encourage you to go back and look at it and do this cost comparison. Is the gain of that direct quote worth the cost of my fees and any license fees that you may incur? Because a copyright holder can charge you to use their quote, and it's getting more and more expensive, if you will. So, I'll try to talk you out of using so many direct quotes Give it the cost test. And then if it is, then I'll give you a hard proposal, and I'll say, okay, I will go through the clearance process for X number of items, if you will, and here's my not to exceed price. So I don't like surprises, so I don't charge by the hour typically unless it's just a straight consultation. Like let's say this was a consultation, then you would pay me for 30 minutes to talk about your copyright issues or whatever else it might happen to be for that. So once that's done, then I proceed and I'll go out and identify the copyright holder. I'll seek permission for how you want to use it. And then once I get a quote back, then I may help you negotiate the fees if I think the fees are not appropriate, or if you don't like the terms and conditions, I'll try to modify those, although it's getting more difficult to do anything about that. And then you'll make a decision. Do you want a license or a grant to do that or not? And then, you'll pay for the fee of whatever the rights holder. Now, a lot of times it may be gratis. They won't charge you at all. Sometimes the rights holder will come back and say, no, you don't have permission. Well, you don't have any choice then. You just have to take it out of the book.
Right.
And they can do that for whatever reason they want to. Maybe they don't like the context. And some people will ask for the page of, the page before, and the page after their quote to see how you used their quote. And they can come back and say, I don't like your treatment. You don't have permission. You just have to take it out.
Yeah. Brilliant.
So,
well, I think that's really good advice. Thank you so much. If people want to get in contact with you to talk about these services or to book up a consultation, where's the best place to do that?
Go to our website, and it's just thecopyrightdetective.com. And there's all kinds of contact us forums and all those kind of things in there. And also, if you want to hear what I'm talking about AI, there's a page in there called Workshops, and we've actually got some recordings that you can actually listen to. So there's a couple of presentations that I've done, and there's a number of podcasts. And with your permission, I'll actually have a link to this podcast so that the audiences anywhere can actually see what you and I talked about today.
Do I have to give you copyright permission to put it in there?
You have to give me permission not to link it, but if I wanted to put your recording in there, you own the recording according to U.S. copyright law.
How much do you think I should charge you to give you permission?
Yeah, well, I always hope for gratis. So anyway,
yeah. Well, thank you so much for coming on. It's been great chatting, Dan, and we'll speak again soon.
Thank you very much.
Thank you so much for tuning in to the Publishing Performance Show. I really hope you found today's episode inspiring. I absolutely love chatting to authors, writers, and people in the publishing world. Now, just before we wrap up, I want to tell you about our Publishing Performance Starter Packs. These are curated episodes and collections organised by topic that makes it super easy to find the exact content you're looking for. So whether you're wanting to deep dive into marketing strategies, explore productivity techniques, or focus on any specific area of publishing, we've organised our episodes into targeted playlists just for you. And you can find these all at teddyagsmith.com. And also, whilst you're here, let me tell you about Publishing Performance. It's the #1 platform for authors who want to increase Amazon book sales but aren't really sure where to start. Now, this show is all about helping you to sell more books, and if you're looking to boost your publishing game and to maximise your book's potential on Amazon, then Publishing Performance is designed to help authors just like you to grow your readership and to reach a much wider audience. Now, I know that Amazon ads can be slightly complicated, which is why Publishing Performance is like having a personalised ad account manager to create your ad campaigns for you, to choose your best keywords and to make adjustments in real time and to optimise them over time to save you money and to make more sales. Now, if you're investing in ads, you really want to make sure your investment is being used effectively, and Publishing Performance does just that. It aims to make your budget go further, improve your organic rank, and target keywords more effectively. You can get started with Amazon ads for free for 30 days at publishingperformance.com, and there's a link in the show notes to get that free 30 days trial.